conflict between rights of children and right to choice of young people, particularly because of the enactment of this new law, which is called Protection of Children from Sexual Offences Act, where the age of consent has been rendered immaterial, and which has also caused a kind of crisis, because that will create a lot of problem, because the courts have been very consistent in acknowledging the age of consent, 16 years. So if there is an allegation of rape because of the sexual relation between young people below 18, right? When I say young people, below 18, then the consent of the girl, if the girl says that I had consented to it, the higher court can quash the FIR, and then the person who is accused will get benefit. Now this legislation which now has been enacted makes any sexual activity between young people who are below 18 years very problematic, because then you will be booked for one of those 5 offences: sexual harassment or penetrative, sexual assault. That will create lots of problem. I wanted to discuss that. I don't have much time, but then the issue is far more complicated than that. Delhi High Court has recently issued a comprehensive full bench judgment, 3 bench I will say, basing its judgment on 4 cases: Lajja Devi 2008, Mahadev 2008, Devender 2010, and Lakshmi Devi 2011. These are 4 cases where a minor girl exercised her right to choice and married a person who was adult. Now, what are the consequences? What is the status of the relationship between both of them? Whether the marriage is valid or void or legal or illegal? What is the custody related position? Because under Hindu law, husband is the guardian. So if that marriage is lawful, then how to deal the question of custody? I wanted to highlight this judgment in a big manner, but I don't have time. That's my crisis. But the whole issue, privacy and all, I cannot deal today. I'm sorry for that. I wanted to discuss that, not privacy. Choice, the status of relation between young people. Some may be minors, some may be between 18 to 25. And then their relationship with all these laws. That's an area of huge debate. But then when I was going through this judgment, actually this judgment, please take note of this, because if you read this judgment, it's a singular judgment. All these 4 cases have been decided by a singular judgment. Reading this judgment will give you hints. So bench is constantly dealing with the problems and saying that what the hell Parliament has done. That's what they are saying, in effect. Because in one law, Parliament is saying something else, in the other law, Parliament is saying something else. In one law, you are saying that the child marriage is bad, but in all other laws, you are actually giving a legal sanction and protection to child marriage. For example, a husband can rape his own wife without any legal consequence. No legal consequence if the wife is above 16. Right? What kind of logic is this? Indian Penal Code. Husband will have no persecution. If the wife is below 15, then you have 375 coming on you. But if the wife is above, and then you have the Child Marriage Act, and then you have the Protection of Children from Sexual Offences Act. How a police officer or anybody for that purpose will deal with. So this is said to create a huge crisis which they have to deal with. Now, in the morning there was an argument about sex education. In fact, while deciding the rights, consequences of certain relations, High Court has mentioned about non-availability of sex education to young people. That can be used. High Court has taken note of that sexual education is not available to our young people. That's why marrying them or opening them towards a sexual relationship may have serious consequences. I will read out that. A lack of education also means that the young brides often lack knowledge about sexual relations, their bodies and reproduction. This denies the girl the ability to make informed decisions about sexual relations, planning a family and her health. Yet another example of their lives in which they have no control. This is coming from Delhi High Court. 3 judgments. So some kind of argument. Me and Govind were discussing, when we deal with this issue of child marriage, actually there are 2-3 interests or maybe some kind of human rights standards or principles which we endorse and advocate for pitted against each other. Right? How will you look at a relation from the reproductive rights perspective and also from a child rights perspective? How will you deal with the situation where a child is making a decision to be with somebody? When I say child, actually it's a whole range, right? Up to age of 18 years. But then there are divisions. 16 to 18 is a range. Then above 15, because under Muslim, and then the personal law comes into the scene, right? Option of puberty. 15 year, Delhi High Court has said if a Muslim girl decides to exercise her option of marrying somebody and she is above 15 years, she can marry. Then also, what is the scope of secular law? Whether the personal law will prevail or the secular law will prevail. The answer in this judgment is very ambiguous. At some point of time it's saying that secular law will prevail over all other personal laws. So I mean, full of problems, and it's very difficult to locate what our law is actually saying. I will only recommend you to read this. I would have made a detailed presentation on this. Criminal Miscellaneous Application number 1001 of 2011. Or maybe you can find the second case, writ petition criminal number 338 of 2008. 338 of 2008. Just read the judgment. It's only 62 page long judgment.
Previous one. Can you repeat the previous one?
It's the same. I mean, it's a cluster of petitions. So if you find this one, you will find all others also because it's the same judgment.
No, this is 2011 now.
Ha.
Order is 2011, but the petition was filed.
Order is 27th July 2012. The judgment has come on 27th July 2012. But then the writ petition is writ petition criminal number 338 of 2008. Then writ petition criminal 821 of 2008. Writ petition criminal 566 of 2010. And then criminal miscellaneous petition 1001 of 2011. These are 4 cases which have been clubbed together, and then all the issues. Reading this judgment will also bring lots of issues where High Court is suggesting amendment to Indian Penal Code 375. They are giving suggestions to Parliament saying please amend it, otherwise it's going to be very difficult. Then Child Marriage Prohibition Act. Then also Hindu Marriage Act. So 5-6 major acts have to be examined if you want a clear picture of the position of law vis-a-vis rights available to children. I mean, I'll say, for example, if I am a child, what option I can exercise, what option I cannot exercise. And if I exercise that option, whether I will be persecuted or no? Because Prohibition of Child Marriage Act, it does not say that any marriage between minors is illegal. It exists in law. Viable. At some point of time, you can exercise the option, but at the same time, it also provides the punishment. So you definitely go somewhere, either some observation home or some children home. So what kind of law is this? I think I will have to finish with this, and then maybe if there is time tomorrow, then we can again have a discussion on this.
I just want to comment on when Govind was saying that child marriage